Welcome to the Encrypted Economy, a weekly podcast featuring discussions exploring the business, laws, regulations, security, and technologies relating to digital assets and data. I am Eric Hess, founder of Hess Legal Counsel. I've spent decades representing regulated exchanges, broker-dealers, investment advisors, and all manner of fintech companies for all things touching electronic trading with a focus on new and developing technologies. So, I am joined today by Brandon Ferrick and Jordan Schwartz, both co-members, co-teammates with the LeXpunK Army. Welcome.
Hey, Eric. Thanks for having us on.
Hey, yeah, thank you so much.
So, the LeXpunK team put out a comment letter on Reg ATS last week on April the 18th. And, we have here a core component of the working group that put it together, myself included. Before we launch into it all, I'm going to give Brandon and Jordan an opportunity to introduce themselves, their background, their journey into crypto. I guess I'll start with Jordan.
Yeah, no, that sounds great. So I'm an attorney. I started my practice as an attorney working at a large firm in a capital markets practice in technology and life sciences, and that really ran the gamut from working with startups and VC firms all the way through to mature public companies and working with them on public offerings and Exchange Act reporting, things like that. So I've always had a foundation of my practice rooted in securities practice and in markets, though not directly in trading and exchanges. So this was a particularly interesting project for me to do some learning along those lines. I've since moved on from that firm. I'm still in private practice. I'm based in Michigan, and over the past few years, my practice has shifted from capital market securities to mergers and acquisitions. There's not a ton of that in the traditional sense in crypto. And so the types of things that I've been doing in decentralized finance and crypto is largely out of a labor of love at this point. And my Genesis block, if you will, I bought Bitcoin at the top in 2018 because I'm a fantastic investor. But that is really when I started paying attention and kept paying attention, got a little bit turned off by some of the Bitcoin maxi ethos, but kept my head in the game. And then, DeFi summer came around last summer, and really the light bulb moment for me in terms of crypto as a legal practice and as a legal discipline came with Constitution DAO. And that project launched, and just the idea that this group of people was going to get together, raise funds. And, at the time, at the inception, it was to own a fractionalized piece of the Constitution, although that ultimately ended up, not being the plan once people got smart about it. But to see that sort of new, at least new to me and very popular sort of novel organization structure, that's what made the light bulb go off for me. And I'm thinking, okay, as a business advisor and a lawyer and a corporate lawyer, like I need to know more about this. I need to study up on this. And because I think this is the next thing. It's just a foundational shift in organizations and the way that people organize and execute on businesses. So that's somewhat rambling, but that's where I'm at. And I got involved in LeXpunK and LeXDAO and just started doing things. And that's one of the beauties of this space is you can just jump in and peel off projects and start doing. So that's how, we ended up hooking up.
Awesome. Brandon.
Hey, so I'm Brandon. I'm also an attorney. I'm currently the general counsel for Injective Labs. We are a software development company that does a lot of work in the DeFi space to provide more seamless solutions to folks who want to get involved. I started my legal career at Sullivan & Cromwell under the purview of Ryan Miller, to whom I owe a massive debt of gratitude for the opportunities to get involved more in the crypto space. I started my foray into crypto, I think back in 2013. I'm a young attorney, so I was still in college at the time in 2013. But I met a friend who I got interested in Bitcoin, and I believe Litecoin at the time. And sat me down. We wrote like my private key on a notepad on a piece of paper that I stored in like my safe in like my little college apartment. I set up like a Litecoin mining rig, and I was off to the races. Really, just as an investor. I didn't get academically involved in crypto until I went to law school. I wrote my note for the law journal on blockchain technology and Delaware appraisal rights, so shareholder minority rights in the event that they disagree with the direction a merger is taking them. They get basically like an opt-out right, to get cashed out at fair value. And there were some issues there that just made sense for blockchain technology to rectify, layers and layers of intermediaries and proxy plumbing issues that could get resolved just by having folks interact directly with the companies that they're invested in. After that, I did another use case paper on digital assets, blockchain technology, and event ticket sales and fraud. Sort of like low-hanging fruit things, but important things to think about. After I graduated law school and went to Sullivan & Cromwell, I was part of the general practice group, so I really got a wide array of experience: VC, M&A work, bank regulatory, derivative securities regulation, and I had an opportunity to work with a lot of the larger centralized players at the time, and a handful of nascent, fun token projects that I won't name. Because most of them aren't around. Sort of fortuitously, I fell into this current crypto job. One of my close friends, Paul Menchov, is former, or I guess, co-founder of AngelList, CoinList, and Republic. And he called me one day and said, "Hey, I'd love to introduce you to some crypto folks." And at the time at S&C, I thought, "Oh, awesome! We can grow the practice out." And really kick things off. But it sort of devolved into a trip to Bitcoin Miami, which ended up turning into a job offer after a couple of drinks and meeting the team, which was fantastic. Definitely no regrets or second guessing myself. The folks that I'm working with now, the opportunities that I have to meet with founders and hear what's going on and really push and develop the space is a dream. And being able to work with amazing folks like Jordan and Eric, it's really something that I never would have possibly imagined could have happened so early in my career. So I'm incredibly humbled and grateful for that.
I know that people know your background because it's your podcast, but does it make sense? I'd like to turn it over to you to ask specifically about your background in markets and some of your experience that directly relate to exchange regulation and things like that.
I started out my practice in private practice, doing mostly contract corporate work. Ultimately got hired by a company known as Automated Securities Clearance, which was the dominant order management system on Wall Street for equities. Bob Greifeld, who later became CEO of both NASDAQ and Virtue, formed this alternative trading system known as Brute. So it was one of the first alternative trading systems out there. This was in pre-2000, in fact. And so I worked on that whole application and approval. I basically negotiated the deal with Merrill Lynch, Morgan Stanley, and Goldman Sachs and Knight Securities to form this consortium alternative trading system, which they all did exceptionally well on. And then I ultimately left to join Bloomberg, where I worked with the Tradebook system and their order management system. And there I started to shift my practice a little bit, where I started sitting down a lot more, even more than I did at Brass, with developers. So I got heavily involved in crafting, spec writing, as well as rules. And then from there, ultimately joined Lehman Brothers for the purposes of managing electronic trading. Was there for about 5 years. Basically started getting involved heavily with rulemaking and programming, again, working closely with the development team. I formed a number of ATSs, work with programming for the prop trading desk, algorithmic trading. I'll just tell a little story. When I was interviewed, I was told we need somebody to do that e-commerce thing. That was what the headhunter told me. And I said, I don't do e-commerce. I'll tell you what I do. You can take it back and determine whether I should advance. And like my first 3 interviews were all gatekeepers. And I said the same thing. I said, I don't think what you described to me is not what I do, but I'll tell you what I do. And then you determine. I think by the time I got to where I was probably the only person who was qualified because everybody else was brought in for e-commerce. From Lehman, I left in May of 2008. That's right. Note the month, May of 2008. To join a stock exchange or an ATS that was becoming a stock exchange. And I worked on the stock exchange application through the whole rule filing process, everything with the SEC. We got up and running. And then I left there to form basically a pink sheet trading platform where I had some big players. Like I had 8 players on a baseball team, but I never got the 9th. And so that didn't advance. And then fast forward, I started getting heavily involved in, I started a private practice, got involved with cybersecurity, as well as capital markets, traditional, and then started morphing into markets that were centralized exchanges. And those were sort of my first few big ones back in 2000. It started to morph from 2015. Started getting involved with a couple of very big platforms. Fast forward again, I just started picking up more and more crypto along the way. And yeah, that's my story. And now we can move on.
So no, I think that's really interesting. And so when you saw the release in January of 2022 that comes out with proposed amendments to the definition of exchange and communication protocols, did your eyes light up? Like, what was your initial reaction when you read through it? I mean, because this is like a convergence of a couple of things that near and dear to your practice.
So literally, Brute at the time was one of the first ATSs in existence. Like we had been on the starting line waiting for the relief that the SEC gave. And I can tell you that the mood, the anticipation was a very different feel. And I think this is something that we bring out in our comment letter, which is there's a tale of 2 commissions here. Back in 97, 98, there was a SEC commission that was trying to figure out how to get to the right place. They did have regulated market participants, but the statutory structure just didn't accommodate this e-commerce, right? Or electronic trading. Like it was new and they were struggling with it. And so, and they were receptive to it. They were focused. They did concept releases, but even beyond just the whole, when we look back at history, we say, oh, there was a concept release, there was a rule filing, there was discussions, but there was actually so much more, right? Like these are words on paper, but there was active engagement by the industry with the commission at the time. And that's why like Chair Unger, who spoke about it, she was moved. She saw it as a major change and the need to partner with the industry to take the markets into the next stage, into this ATS. ATS wasn't just about ATS. It was about how do we handle electronic trading, which the whole street was struggling with. How do we make it more efficient? It was the start of something very significant. In much the same way, we should be at the start of something very significant, but we're not. So it's a very different mindset. And the mindset today is, it's sort of pushing back. Now you see with the Biden executive order, there's a recognition that, hey, listen, things are changing. We have to adapt. But I don't know if the SEC has really addressed the magnitude of their task right now, that they're basically playing whack-a-mole in a number of different fronts across the regulatory system. And it's creating this crazy disjointed effect and negative impact on the whole market.
And it's even pushing some of these market participants away from wanting to have these conversations with the SEC for just fear of an enforcement action. One of the things that we've been hearing over the past couple of years has been come talk to us, have the conversation. But in practice, you just kind of get this ping pong match where you're pushed between, enforcement and corporate finance or trading in markets. And there's no clear answer for a path forward, A. And B, if you start to have these conversations and it turns out that the kind of system you have just doesn't work right now, well, you're stuck because you're going to get an enforcement action pressed against you. If you try and push this product out, that can't be regulated right now.
That's right. That's right. It's a great point. We'll take another moment to sort of circle around what the LeXspunK Army is, right? So, Jordan, you touched on it a little bit. Who wants to take a crack at summarizing it, and we can all chip in?
Sure, I'll give it a stab. I find LeXspunK Army to be a collection of incredibly bright, dedicated lawyers who want to see positive changes in the crypto ecosystem. They want to help founders. They want to push narratives that make sense for the broader community, for adoption, for growth. And the idea isn't for these folks to make an extra buck or to have a side gig. It's really boots on the ground, and that's why we call ourselves an army. The LeXspunK Army, a group of attorneys that are working to make crypto a more habitable place for market participants.
Right. And I sent the comment letter to a couple of news organizations and a couple of people I know who report on crypto. And one of them came back and says, "What is LeXspunK? It sounds like a bunch of lawyers who are punks." And I'm like, well, I guess everybody's a punk to some extent, but Lex, obviously law. Punk is really a derivation of cypherpunk, which is sort of that view, it's not completely anti-institutional, but it's more of a distrustful of the general hierarchy. And again, that doesn't mean we're all advocating for Fight Club, but it does what it does mean is like crypto is based on more trustless solutions, right? Trust but verify. It's in many ways the notion of a cypherpunk isn't really that different from saying, we shouldn't just trust institutions because they're institutions. There should be trustless mechanisms so everybody is actually on the same footing. So that is a core component of the ethos of the LeXspunK Army. Jordan, I'll let you supplement with your little piece before moving on.
Yeah, no, I think those are both great. I think that it's the business of LeXspunK predominantly carries on in the main Telegram chat and through working groups. But I think part of the ethos is also that nobody's taking themselves too seriously. People are highly capable, some of the smartest people that I've ever interacted with. And at the same time, this chat is interspersed with, some groundbreaking ideas and thoughts and threads with, some GIFs and other, savory and perhaps less savory, memes and things. And so it's just it's a genuinely fun community to be a part of. And it's a group of people who are not taking themselves too seriously, but doing, very serious and significant things in the digital asset space.
Right. From a wide variety of projects. Also, two other points is there's developers, there's people who are just engaged in the community as well. And I guess the other point is it's really sort of more fair launch oriented for DeFi projects, projects that aren't necessarily backed by VC. So like, how does a fair launch DeFi project succeed? What are the tools that it needs to succeed? How can we help these projects succeed when they're trying to get off the ground? So I think that's also a very critical component of it. I'll also note that that a lot of LeXspunK's works, including the comment letter, is made possible with the support of Yearn, Lido, and Curve, who have provided grants to the Army as well. All right. So, and I guess before we even go even further into the Reg ATS comment letter initiative, what different projects have you worked on in addition to the Reg ATS comment initiative? So
I had a couple of conversations with some founders and some investors, I guess, over the course of last year, and there were just inefficiencies that I recognized existed in the fundraising process. Some of these documents are very long. They're like oftentimes one-sided. You kind of get them, SAFs or token purchase agreements I'm talking about. You get them from different jurisdictions. And so I wanted to try and push some standardization into these markets, introduce some efficiencies, make it easier for folks to, get to the finish line and start building. So one of the projects that I put out was a one-page SAFT, one-page simple agreement for future tokens. It's on my GitHub. You can check it out. It's an amalgamation of a bunch of SAFTs that I thought were pretty fair. But basically, it takes the important pieces. What are you getting, and when are the unlocks? Puts them on just this one particular page, and then pushes to the back references to an annex and a glossary.
Awesome. What about you, Jordan? I've already shouted out to Jacob's Law of Code a few times. Jacob's great.
Working with various communities, some of which have been more successful than others in terms of organizing and really just getting off the ground and working through, what ideas they have and trying to figure out how to best, bring those to market, if you will.
Yep. And then, on my part with LeXpunK, I did some work early on with foundations, and came in, and then got heavily involved in the cooperative side. I was doing it at the same time I was sort of running that stream in my podcast and sort of putting together different structures for how cooperatives could fit into a DAO-like structure. And then there's Reg ATS, and also doing, I bounce in and out of other working groups, but I think cooperatives and Reg ATS certainly were the heaviest lifts for me in terms of engaging. So, all right. So now we can get into the Reg ATS comment letter, which we've touched on already. Let me just frame this question. Why did we get all spun up about Reg ATS? Not just us, everybody. What caused, if you look at April the 18th and 19th, it just was like the slew of, there were a lot of different comments from people kind of submitting maybe more templated versions with their own story about why they objected to it. But then you hit you started hitting toward the deadline, and you got, all the major lobbyist group, Coinbase as well, A16Z, Delphi, Delphi had a very, in-depth one. A16Z certainly did. And then you had a lot from other groups, CoinDesk, was a DeFi Education Fund, Blockchain Association. I won't even go into it. It's just a laundry list. Why did we get all spun up about it?
So, I think it's a combination of things. At the outset, the response time for this was limited to 30 days after the notice was published in the Federal Register, which is just a remarkably thin timeline to put out thoughtful comments here. It's tough to say that when you see the number of well thought out comments that have been produced in this short amount of time, but certainly that was like an impetus for a bit of rage from the community that, hey, you're putting out this 591 page proposal that's going to have significant, substantial impacts. You're not even mentioning DeFi, but with all of your eyes and attention on crypto, you being the SEC over the past year, 2-3 years, it's a little unacceptable. So I think the community saw it as a bit of a sneak attack, a bit of unfair with respect to timing. And perhaps, Jordan can speak more to this, but just the scope of it was absolutely far too broad and sweeping if what the SEC is getting after is crypto.
Yeah, and I don't have that much to add on the scope piece because it was certainly just massive. But I think I agree with you that it's a combination of a number of things, and I think that it's the first time, at least in a while, that these organizations and the public have had an opportunity to make their voices heard with the commission in some formal capacity. And it not only is this particular the proposed changes in this particular release are particularly egregious if interpreted in the way that many participants and organizations think that it would be interpreted to capture decentralized protocols and digital assets, but it really gave people a forum to say, we have a lot of fundamental issues with the way that the commission is going about regulating or not regulating these markets. And so there was a focused reaction, of course, on the release, but the undercurrent in a lot of the comments, including ours, is let's take a step back here. We need to have a conversation about this.
Right. And I think one of the things that set it off too was Hester Peirce called it out in her dissent, and that attracted a lot of attention. I mean, the funny thing is about this release is it was very focused on the fixed income market. Like there was a concept release on it. There was a lot of thought put into this whole structure, all geared toward government fixed income. That was the basis of it. And then at the last minute, they're like, okay, well, we're going to add this part of it too. It caught everybody off guard. And what I find intriguing, and I actually wrote an article about it, is the securities market even viable? Which is when you think about the trinity of market structure, to me, this is my definition. I know others are going to disagree. There's like three main buckets. There's what are you trading? How and where is it trading? And how and who is intermediating and facilitating it? And all these definitions, all these questions, all these three buckets keep coming up. So like when you're trying to regulate the how and where is it trading, you kind of also have to know what is being regulated and who is intermediating it. They all kind of work together. So and that's why one of the major things we talk about is get a concept release, because this is it's crazy. Now they have the broadening of a dealer definition. They also have another proposal out for security-based swap execution facilities, which also would cover digital assets. You have to come within the remit of the market, but of course we want to hear what you have to say, even as we're changing the market or the regulatory structure, which you have to comply with. So anyway, we kept the comment letter a little more tamped down than that, though, right?
I hope so. You guys definitely came out guns a-blazing.
Yeah, well, there's
language. But Eric, I think you hit the nail on the head with the point on the definition of securities. The threshold question here, the major jurisdictional hook is: are we dealing with security transactions, investment contracts that would be considered a security under the securities laws? Because if they're not, if these things are just commodity assets or non-security assets, there's not an issue here. The SEC is not going to have authority to regulate. And so a lot of the hullabaloo that people are dredging up now is all warped around this idea that the SEC thinks everything is security, that you'd be hard pressed to find certain things not to be securities in these markets, or that more than half of them must be, whatever formulation Gary Gensler is using these days. But until we get some more clarity there, it's really tough to see that, it's difficult to see that proposed rulemakings coming out in the future wouldn't have some sort of impact on crypto markets and digital assets and blockchain tech, especially as these markets and products continue to develop and grow.
And so let me ask this question before we even get into our comment letter, which I keep pushing off, right? Why does this matter? Not just to the people who are in crypto, but why does this matter more broadly?
So I think at a high level, it matters for economic development and innovation in the United States, and providing builders in the space and market participants more broadly avenues to create these technologies and to develop these technologies, contribute to these technologies, participate in these markets in the United States. And so I think, for me, and I think for many of us, that's one of the core issues.
But if I'm somebody who's not in crypto today, why should I care? I'll throw that to Brandon.
That's a good question. I think I believe it was the Delphi digital paper that said it best. What we have now, at least with respect to the Reg ATS proposal, is a clear-cut instance of unelected officials unilaterally making decisions that could have material impacts on new market participants, folks that wouldn't otherwise be regulated. Borderline and abuse of power. I don't think ultra virus is the right word in this situation. I had a conversation with Louis Cohen about this, and I wasn't sure if ultra virus was the right word, but it's certainly outside of the scope of what you would expect and how the American regulatory environment is structured. And it's not fair. It's not right. It's not what our expectations are. And it can seriously stifle innovation in the space by allowing folks to almost unilaterally put a de facto ban on a particular nascent industry. And with respect to crypto specifically, it's designed to empower folks to lift themselves up by their bootstraps, to find that American dream that's dying every day. You know, the number of individuals that I've had the opportunity and pleasure to have conversations with who've lived through, the financial crisis and had their homes foreclosed on and couldn't, afford to put food on the table for their kids, and through digital assets and crypto have been able to save up money for a college fund for their kids, start businesses, become, miners and validators, and really change their lives for the better. It's staggering. And I think a lot of the times, regulators with particular agendas may get lost in the work and not see the broader picture here, that we're working together towards something bigger, a new economy, an encrypted economy, something that really has an opportunity to create a financial revolution in the world, and to position the United States to be a extremely powerful player in these markets.
It's funny, like going back to the revisions to the tax code and back last year when everybody, there was a major impetus for people getting involved. I remember like talking to Hyperledger, and like they were just, and again, I'm not picking on them. That's maybe not their focus. But I'm like, do you realize that this impacts you directly? Like this will impact the adoption of your network. Similarly, this also adopts Hyperledger, because so many of the things that they do on Hyperledgers is distributed ledger technology. And to the extent they want to trade on a public blockchain with it, because they do have some integrations, it impacts them there too. But yet they are unaware. And so if Hyperledger writ large is largely unaware of this and unable to appreciate the impacts when they're going to be direct, there's a large swath of the population that also fails to appreciate it, like how it actually is going to impact what they do. Because certain things that they may otherwise be able to do conveniently, now there's going to be the insertion of an intermediary, adding more friction, adding more cost, limiting their ability to participate in these sorts of things. So there's that. All right, so I guess maybe we'll get into the comment letter. We're there. We're 40 minutes in. We're going to get into the comment letter now. So who wants to sort of summarize the primary points?
I'll take a stab at the first one, I suppose. It kind of echoes from the last point we were just discussing. That there wasn't an informed rulemaking on the particular aspects that we're complaining about, which is namely digital assets. The SEC has had, a hawk-like focus on crypto and digital asset markets for a handful of years now. They're aware of this technology. They're aware of these systems. They're aware of where and how these things trade. But what they're doing with this rulemaking is promulgating a set of rules that would, expand the definition of what's an exchange, bring in a new concept of a communication protocol system that would arguably capture, based on how the SEC is describing it, a lot of these systems. I said it before, I'll say it again, 591 pages, do a control F, take a look through, not a single mention of digital assets, crypto, AMMs, or anything, of the like at all. No opportunity for notice or comment on this in previous concept releases, discussing these new proposals, partly because what they're adding in now is novel. But no indication of a thoughtful, meaningful opportunity for participants in the market to speak their minds. And that's just not right. It's not right under the APA. It's not right as a policy matter.
Yeah. So my emotional well-being remained in check, although I was, when I got to the economic analysis, I was just sort of blown away initially. Like the SEC actually had an opportunity, I believe, to have modified the impact analysis or even pull or delay the filing in the Federal Register in response to there were a large number of comment letters even before the publication in the Federal Register, which keys off this 30-day comment period. They could have pulled it. And they certainly were aware that this was something that the industry was aware of, and they probably should have. Not clear to me why they did, but maybe there's good reasons, and maybe they'll just sort of address it in when they finally publish it. But when I was looking at it, I said, this is, they had like 22 impacted communication protocol systems. They had financial projections that were just so far off. And I was just, blown away. And I said, there's something fundamentally wrong. And then I said, there's something even more fundamentally wrong because this happened after Dodd-Frank. Like when the Dodd-Frank, there was a flurry of rulemaking, and a number of those rulemakings were subsequently challenged. There was a number of cases that we refer to in our comment letter. I'm not going to interpose them here. This is a prompt for people to go and click through the comment letter and read it. But we lay it out, these different cases, and some of them even relating to what is a security. And the DC Circuit Court, for those who remember at the time in 2012, 2013, the SEC was struggling in the courts. They were repeatedly getting struck down with at least 3 cases. There were a number of settlements in the process as well. There was a lot of issue with the DC Circuit Court coming in and saying, listen, you didn't have a process here. Your impact analysis was deficient. You were loading in facts. They were sort of conclusory. You didn't engage. You kind of just pass this off as if it was an impact analysis. You kind of just you didn't meet the spirit. You didn't even meet the fundamental requirements. And this is not just the APA. This also exists in the 33 Act and the 34 Act. You failed on all these fronts. In one particular case, which we included in the comment letter, the judge literally chastised the SEC in its order for how dramatically it had failed in its impact analysis. And this wasn't an insignificant event. This was recognized by the chair of the House Oversight Committee, as well as other members in Congress. There was a lot of concern in Washington over where the SEC had gone in their rulemaking, how they had exceeded it, how they were suffering these strike downs in the court, the vacating of these rules. And it seemed that, we don't want to see this happen again. Maybe Dodd-Frank was different. We had to do a bazillion things, but we got to get this thing fixed. And in fact, the chair of the House Oversight Committee basically wrote the Inspector General of the SEC and said, you have to do a report on this. I want a full accounting of what happened here. I want to understand why we were so far off and what you're going to do to fix it. This is a big deal. The Inspector General actually did a report, which they published in 2013, which we also cite in it, where they basically did a complete review. They adopted policies. There's a lot of language about saying, we're going to make sure that we don't screw this up again. The Office of Economic Analysis, not Economic Analysis, what's the office? I'm blanking, but the office where they do the economic analysis in the SEC. The director, because they changed names too, so it's hard to keep up sometimes. But the director, exactly. But the head of that office actually did this whole speech to a large industry group in DC, lauding how, basically extolling what they had done differently, how they had turned the corner, how they were going to do this economic analysis going forward. We got all these procedures. We responded to the report. It's not going to happen again. We recognize we're working hard. We're going to make sure this doesn't happen. And so in that backdrop, in which we sort of lay out in our comment letter, despite that whole backdrop, here we are again. And in fact, we're not just here for the ATS. It's here for the dealer. It's here for swap execution facilities. It's here for what's a security. Whatever we're doing, like the SEC can't say you have to fall within the remit, but we don't have to consider you when we change the rules, right? And now it's just a method of regulation by enforcement. But basically, back to the letter, we lay out this whole sort of dynamic of not just, hey, this is what the case law says, but we also sort of walk through the evolution of there were these cases, then there were all these other things that happened where the SEC itself embraced this notion, or at least a prior SEC embraced this notion. So that is largely the APA argument. But yeah, let's move on to so I think we covered the challenges in the rulemaking, and we thought that a proper approach was, hey, you did a concept release for fixed income. You did a concept release when you did Reg ATS. It's time to do a concept release as it particularly as it starts to relate to digital assets. Don't just jam it into a rule that's covering other topics when there are some unique considerations and your impact analysis is by definition going to be defective. I mean, if your impact analysis had 22 systems, none of which included digital assets, how are you ever going to get it right? Right?
I just, like, anybody who's listening to this podcast or watching on YouTube, just go on CoinMarketCap and sort by DeFi and see how many hundreds of different protocols exist out there right now in DeFi to trade assets. It's astounding. And the amount of money that these protocols are valued at in market capitalization and also in total value locked is in the billions of dollars. It's absolutely insane to just completely ignore this entire, massive market.
Right. Indeed. So, yeah. And so the SEC has to figure out a way to sort of incorporate those, particularly if they are going to be the regulated participants who are, as we elucidated, probably the least prepared to comply. Right. It's clear. Like, so.
Yeah. And maybe it makes sense to get into that a bit later too, because there's a reason why these folks are the least prepared. The language is so broad that it's going to capture the technologists, the devs who are creating stuff. I'm happy to dive into that piece of the comment letter as well.
Sure.
Yeah. So one of the changes to the interpretation of the definition of the Exchange Act under Rule 3B16A. So I'll give it the original, I'll give you the changed version. So the original version, the SEC interpreted exchange to include any sort of organization, association, or group of persons that brought together orders for securities from multiple buyers and sellers and used established non-discretionary methods to have those orders interact. The change, one of the changes would be to that second prong, uses established non-discretionary methods, and the SEC is proposing to replace uses established non-discretionary methods with makes available established non-discretionary methods. The SEC's reasoning for this change is they wanted to catch like direct or indirect provisions of these established non-discretionary methods, which include communication protocols. They're really trying to capture communication protocol systems that take more passive roles in providing ways for market participants to interact. The nervousness here is that this makes available piece would capture folks like individuals or groups that are hosting like DeFi front ends, just interfaces, and devs, right? It's unclear whether this interpretation of makes available would be limited to just folks who are operating a centralized platform for bringing together orders and securities of buyers and sellers, or it's more broadly construed to capture devs who create open source AMMs or host interfaces that just visualize what's really going on with those smart contracts, just a more seamless UI or UX for users. It's totally out of left field. It's like brushing up against potentially First Amendment concerns because you do have a right to create code. And this is, I think, one of the more shocking aspects of it. And one of the issues that I think folks were complaining about with the tax changes was at 6050L that would require certain folks to be considered brokers and have to do like onerous reporting requirements for folks that are trading in crypto on their particular exchanges, like their DEXs or DApps. And I think it goes to show it's either a lack of an understanding of how this tech works or just a flat refusal to accept that it's just different from traditional intermediated systems. Whatever the case is, it wouldn't work in these systems, and it would seriously, if implemented, would seriously hinder the growth and adoption of crypto in the United States.
Yeah, and there was a footnote. There's a couple of places where this comes up in the release, where the SEC actually clarifies how, groups of individuals that each individually may have a component part of an exchange could also basically have the full exchange regulatory construct imposed on them. And so I forget the footnote, but it doesn't, it's in the comment letter. It's also, I've tweeted about it, but the language is there. And whether the SEC intended it to state what it did is questionable, but yet it is framed in such a way that it's clear that the intent is to be more expansive. And so that raises very real concerns because, first of all, from an interpretive perspective, having that language in the proposing release certainly opens the door to that kind of construct. And, it just, it really has sort of a significant impact on all the potential players. Like one of the points that I was struggling with a bit, and I got talked off the ledge because it was a little too much in the detail. Jordan and Brandon were like, okay, we don't have to go so on about this. Is you have something called the FIX protocol, right? And I guess I could do this on a podcast. I couldn't do it in a letter, but the FIX protocol is basically, this is how order messaging gets communicated in the market, the fixed income market, the equities market. It is the standardization for how you communicate. Technically, under this definition, and the SEC would, I'm sure, say, well, we don't mean that, of course, but the interpretation, I don't know, like to carve out FIX particularly and to try to keep it for everything else probably isn't the right result because, FIX is basically a messaging platform. It facilitates trading. It facilitates buyers and sellers. It facilitates all parts of the market. So technically, anybody who is involved in sort of designing a system that implements FIX, or maybe coding into FIX or FIX organizations that work on it, they would all be captured by this. And this has never happened. This has never even come up vaguely that FIX should be regulated. It's just ridiculous. And in some ways, there's a lot of focus on some of these new technologies now, but I think in years to come, a lot of these things are going to be less exciting, more boring, because they're going to be part of the fabric, and they're going to be technology, much in the same way that FIX was technology. And just to be clear, it's because of FIX that all these issues started to develop, around electronic trading leading up to ATS. I mean, not specifically, but it was because of FIX, because of the internet, because of all this connectivity that facilitated. So it was also, FIX was part of a revolution in much the same way that the protocols we're working with today in DeFi is.
I will say this. So one of the other changes, I guess this jumps off the point as well. One of the other changes the SEC made, or would like to make, is changing. So instead of bringing together orders, there'd be a system that brings together buyers and sellers using trading interest, including non-firm indications of interest. The change is material, going from bringing together orders to buyers and sellers, because now you have a whole swath of systems that don't have orders in the traditional sense because they're not limit order book based models, but perhaps they're AMMs, and there's individuals interacting with smart contracts on both sides of a particular transaction. I make this point to just highlight that the proposed changes are so broad that in footnote 72, the SEC had to specifically carve out purely messaging-based systems. So, so like, for example, Discord or Telegram or something, assuming that you don't have some sort of function to swap assets on there, I would imagine that those are fine under that the last sentence of footnote 72. But the broader point, I think, is we have this really like sweeping approach to catching exchanges now, where they're going to look at systems of folks who are coordinating to facilitate bringing together buyers and sellers. And so if one person may have a messaging platform, but it has an extension tool that connects you to a place where you could trade, or somebody just happens to link it in the Telegram group chat or something, does that put you in the danger zone? Is that problematic? And I think that when you have to carve out specifically like messaging platforms, in the footnote, it just speaks to how overbroad the SEC is in really trying to capture as much as they possibly can through this proposed rulemaking. And it even goes back to the APA stuff. Like, they're trying to get so much power here and regulatory authority, and there's been no opportunity to have a conversation with them about it. It's almost absurd.
Yeah, I mean that's an excellent point. I mean, if you're so broad, your definition is like, oh, we capture everything, but oh my God, maybe this one particular thing we have to pull it out. Like if that's where you're at, that's not a good sign because that black swan. There's going to be other things that pop up. Like you're not going to get a black, but you're going to get other things that pop up that fall within that category. So maybe black swan's not the right analogy, but anyway. So what other aspects should we be covering from our comment letter here?
ATS broker dealer stuff, Eric, if you want to talk more about that.
All right. Well, I'll touch on it, and we approached it. Some of the other comment letters I noticed, talked more about the host of obligations that an ATS and a broker dealer would have. In our case, we tried to isolate possibly some of the more problematic ones specifically. One of the things that we talked about initially, and I think this is sort of, there are some very specific matters which would probably put some of the listeners to sleep. But I'd be happy to get into it. Be like, well, you gave us fix, Eric, so that's probably enough for today, right? There was a couple of very fundamental themes here. One is about reporting. To the extent that the statutes, both ATS and broker-dealer regulation, impose certain reporting requirements on these platforms, there's sort of a bizarre inconsistency, duplication when you start to contemplate this basically a consolidated audit trail reporting, when a lot of what happens in this space is already reported on the public blockchain, right? So if you create this sort of duplicitous structure, it's really unnecessary, and it's also inefficient. One of the things that the consolidated audit trail tries to do is try to capture order and execution information across a variety of marketplaces. It used to be you'd have OATS order reporting, which was just for equities, and then they started saying, "Oh my God, if we're just looking at equities and in futures, they're manipulating, we don't know. So we have to get all these things together." And so they imposed this consolidated audit trail. And let me tell you, it is not a smooth system by any stretch, right? And in the context of this, if you because like if you do a trade with on Ethereum, you're going to be able to pull it up on Etherscan. You see the full history of executions for what you acquired. So that trail is already there. So then to say, well, you have to take that trail and you have to meet it into ours, and we're going to fine you that doesn't make any sense. We need to sort of, instead of trying to force technology backwards, to force, say, well, hold it, we're just going to take our whole regulatory system and keep it in the 1990s and let the rest of the world advance. Even though we have the capability of making the adaptation now, we're going to force everybody to sort of re-engineer to be less competitive, to be more intermediated, to be less efficient. So that's on the reporting structure. A smarter structure would be to say, wow, we can actually get more if we're pulling it from the public blockchain, and we start to change our models so that we can actually look at the public blockchain as well. That was one component of it. And, then there's this, and there's a lot of these issues about the efficiencies that disintermediation brings. I mean, at its core is we found a way to take open source code and attach programmable money to it or programmable assets, and that facilitates more possibility. And we're never going to be able to realize that possibility if we kind of force ourselves to sort of stay stuck into a 1990s tech, fintech regulatory framework. And another point, which I'll let you guys develop on, is the distinction between a trustless environment and a trust intermediated based environment. So 1933 Act, 1934 Act, there was no such thing as trustlessness. And trustlessness really goes to, where everything is verified in a deterministic way. So you don't have to rely on intermediaries to add that element of trust, right? Because it is technologically trusted, right? You can make it validated through technology. You do not need those intermediaries to do it. And so that is one of the great things that this technology can bring even into a regulatory structure, is this notion of trustlessness. And rather than, again, trying to say, well, hold it, no, we need to kind of take it back, keep it in the 1990s, keep it with the original 1933 Act when we didn't have that available to us. This is the way it's always been. This is the way it has to be. It will limit the ability to really realize the benefits that this trustlessness can bring. So we talk about that in the context also of like AML, because broker dealers have a different regime applicable to them as it relates to AML. And some people say, well, that's good. It's more. It's actually, the challenge is that regime is tailored to a trust, highly intermediated environment, right? It doesn't mean it's better. It means it's tailored to superimpose the intermediation, to superimpose this, collecting honeypots of information about people that could actually be subject to hackers and abuse and even inside trading. I mean, my God, who would think that a broker dealer would ever be involved in inside trading beyond the, right? There's an opportunity. And because of the rigidity and to say, well, it's crypto, it's bad, we have to kind of put it into these boxes that we understand or else it's going to be out of control. By doing so, you're limiting the ability to really realize the benefits, even from a regulatory perspective, of these trustless-based networks. I heard somebody say we shouldn't use trustless anymore because it sounds sort of like, I don't know, it's probably not the right word, but it's not based on trust and intermediated trust. So anyway. What'd you pick up on that?
I think it's important to, question why we have these trusted intermediaries in the first place, and see where the genesis of them came from. It really came out of the 60s, 70s paperwork crisis, right? So, before we had these trusted intermediaries and robust, book entry stock recordation systems to transfer equity securities in the U.S., you had to physically endorse the back of a stock certificate and have it trade hands. And like once the U.S., broader equities market started to grow explosively in the 60s, these physical slips of paper started to pile up like to the ceilings of a lot of these brokerages, like putting them in bankruptcy because they had 4 to 7 days of like trailing time they just couldn't keep up on. Like it caused constant market, shutdowns. And so Congress said, all right, no more stocks trading hands, can't do it. SEC, figure out a solution here. And what came out of it, and you can look at the congressional record, was 2 proposed systems. One system was the system that we know now, where DTCC, through all of its op subs, holds all of the omnibus stock certificates in its own custody in its own name, and issues street name or just beneficial ownership out to the clearing brokers, who goes to the introducing brokers, who goes to you. So you just have beneficial ownership in a share of stock and not record ownership. Your name's not actually on the books and records of the corporation that you own. The second system that was proposed back in the 70s, I think it was like 68 or 69 or something, maybe 72. I can't remember exactly, but it was a disintermediated, like decentralized storage system. It was like what we're talking about now, 50 years later. It's actually insane. And what folks speculate, the reason, the reasons why folks went with a intermediated system instead of this more trustless system was A, technological deficiencies, and B, heavy lobbying by banks who stood to profit by acting as intermediaries in this system. I think we're at that same crossroads now, where we're considering, is the technology ready? Can we push this? Who's lobbying against us? Who's more powerful? Whose voice is louder? And I do think that we're going to see the time for trustlessness. Maybe we should stop using that word.
We got to come up with a better word, though.
Yeah, but
I'll put that on my checklist after killing Meta. Stop using metaverse, but that'd be my second one: is figuring out the trustlessness alternative.
But I think changes are coming, and I think folks are starting to critically examine now some of the failures that this intermediated structure creates. it's not like from a user experience, the efficiencies are all that different. Like perhaps like markets are open 24/7 and you don't need T+2. I mean, we could do T+0 now, theoretically, but we're still T+2. But there's definitely like costs that are pushed on end users for intermediation. That maybe it's for the sake of safety, but intermediaries get things wrong all the time. The more chefs you add to the kitchen, you're going to spoil the soup. So.
Yeah. But I also think it's important, and I think most of the responsible commentary on this hasn't said that this space should be completely unregulated, right? I mean, there is a lot of value being transferred. Who should regulate it? How they should regulate it? It probably I think there's a view like let's not get in its way, but let's make sure that at the very least we're regulating against fraud, that we're improving disclosures, that we're improving transparency, even within an already transparent system, to limit some of the, bad actions, to the malfeasance that we do see. That's important. I don't think anybody's saying that regulation isn't important. It's just, once you start to move beyond, bad actors and fraud, you have to be a lot more thoughtful than you are when you're going. Like nobody's up there saying, no, why'd you bring that action against, some people may be disturbed by the extent that the theories they use in Bitfinex, right? Because they went kind of broad, but nobody's saying, well, those guys should really get off the hook. Those guys were good guys, right? Or those people were good people. It's people are, there was a fraud, there was a Ponzi, there was a rug pull. There's, again, we can question how you went after them if your theory is too expansive and starts to touch on developer liability. But, I don't think LeXpunK or anybody else who commented thoughtfully on this is saying there should be no regulation. It's saying we have to come to the table and figure this out in a responsible way that's sustainable, because it's not sustainable. Anyway, Jordan, your thoughts on, both trustlessness and picking up on anything else?
I don't have much to add here. I think that the only other piece of our comment letter, and we didn't end up touching on it that much, but it's in ours and it's in some others, and it ties in with what we've been discussing, but is this technological neutrality and this idea that trying to impose existing regulatory requirements on these new technologies that aren't necessarily suited to fall in line with existing regulations is creating a system where the commission, by its proposed amendments, is basically favoring entrenched incumbents and stifling in a way these innovative technologies to the benefit of existing market participants. And again, Eric, I know this is something that you had brought up, and in prior drafts we had discussed, and I think scaled back because we didn't want to have the most footnotes of all that. We wanted to have the second most footnotes, but
that's not true. I wanted the most footnotes of all, but A16Z beat us to it. I told Miles, I'm like, you guys beat us out, but we're still number 2. So we even beat out Bloomberg by 1 footnote. So there you go. I think the technology neutrality goes a lot to, like, even when we talked about trustlessness and how it is forcing a choice, or reporting structures, like all these things, there are efficiencies, there are benefits, but yet by engaging in this way, you're limiting the technology. You're limiting the ability to adopt these technologies, and you're also forcing developers. I mean, it's creates some really perverse incentives. Like, we can't pretend like this isn't a global ecosystem, and people will move offshore, and other jurisdictions will get it right. And there's really a limit to how far the U.S. can extend this strong arm. And another point that I often observe is the SEC can't possibly enforce against all of crypto. They can't, So, I talked about this with Yulissa Guseva, who's also cited in the comment letter. But I talked with this with her about it. It's in one of her papers. It's about this game theoretic approach to regulation, most regulators adopt this sort of game theoretic approach. And the notion of the game theoretic approach is you don't try to regulate everybody. You don't make war with everybody, right? You choose, you try to work with the industry and create sort of a dividing line where you can actually work with a large group of the industry on appropriate regulation to then allow you to focus more on those who don't comply with it. I mean, the way you regulate digital assets is you actually work with the community who wants to comply and wants an answer. And if you get that right, they'll also be the first one saying, well, what about him? They'll be the first one pointing out that someone else isn't complying when they've spent the effort to do so. But now's not the time to say, well, the community that we're talking about is only those that have existed to date, right? The entrenched incumbents. Those are the only ones we want to talk to because they're the only ones, who know about this, right? Or who know our old ways of doing things so we can keep, stuck in the 1990s. And that's why I get, one of the things I struggle with is this notion of fairness. You hear a lot, it's not fair to existing regulated incumbents to allow these systems to trade as they do. Well, on some level, even if it isn't fair, you're not achieving your goals. You're undermining your own goals with your approach. But I would also go so far as to say fairness has nothing to do with this. If there's an advancement in technology and there's a whole new way of changing things, I mean, was anybody like saying, well, we got to hold back the cars because all these people who operate the horse and buggies, they're going to be put out of business. We better not have like these computers, these word processors, because Smith and Corona, man, they're going to have a hard time selling and paper and all these things. Sure, there's resistance, but you have to be able to embrace that technologies will change the landscape. And to just simply say, well, you have to stay within our regulation, that may be true in some cases, but not when that rule is not without its exceptions, right? It's important to have rules, but it's also important to have exceptions.
I'll tell you what, though, I definitely miss Blockbuster. Netflix really did a number on that.
or the music industry. So anyway, we're all passionate about this space, and we could probably go on for hours. I know I can. You probably have to shut me up along the way. This market structure, these market structure issues matter, and they don't matter simply for people who are in crypto. They matter because they have ramifications once they're adopted in terms of limiting what we can do technologically, how we can compete globally, how we can be a leader in this. So it's not just about bag filling. It's about where the U.S. is in the ecosystem, the way it's incentivizing its builders and creators or disincentivizing them. So,
well said.
So I guess I'll jump off my soapbox, but as we're at the bottom of our podcast here, anything you want to say in closing?
Do not go gently into that good night. If you're at risk of being regulated out of an industry fight, especially one that's on the precipice of changing the world. That
was a rhyme.
Was it?
Night and fight.
Oh wow! I didn't notice that.
You should write that. Well, we'll have to transcribe that. Figure out if the syllables are correct. But Jordan, how about you?
The Dead Crypto Poets Society.
It's going to be an NFT. We can just watch.
Yes. Well, I can't say it any better than that. But I think that if you're interested in these issues, if you're interested in the ecosystem, crypto, you need to inform yourself and arm yourself with these arguments, and understand that even if you don't think you're in the regulatory crosshairs, just by participating in the market, you are in a number of different and unexpected ways. And I think that's what our comments and what a lot of the comments provide. And I think at the end of the day, we have very specific arguments and problems with this particular regulation, but the industry, we just want a seat at the table, and we want to have a discussion so that we can all think about how to best regulate these markets going forward.
Well said. So thank you for this Saturday morning taping version of the Encrypted Economy. Appreciate you making your time. And it was great to work with you two and the broader LeXpunK team who also contributed to it. So, I think going ahead, we'll probably do, Brandon notes, a shorter comment letter to the dealer redefinition and the swap-based, the securities-based swapped execution facility, and there's a lot coming down. The SEC's in rulemaking mode. It's not just crypto; it's a lot of different things. It's a little bit like drinking from a fire hose, but LeXpunK will try to keep up and stand up for the DeFi builders and creators.
I do want to say before we split, if you're a student, a law student, somebody who's interested in making an impact in the space or just helping out, reach out to us. Reach out to any of us. We're happy to get you involved, bring you into the Telegram group chats, give you some substantive work on these draftings and comments and conversations. We need as many hands as we can get, and we'd love to get more lawyers in crypto. We definitely have a dearth right now, not of talent, but just of bodies.
Yes.
And to that point, I mean, huge shout out to Sam Tuna and Alice, who are law students.
Yeah. His name is
Dean Tiedelman.
Yes, Dean Tiedelman and Alice, who worked hard on it as well.
Both law students, both awesome contributions.
Absolutely.
100%. All right. Well, thanks so much, gentlemen.
Yeah, thanks.
Enjoy the rest of your weekend.
Thanks.
Good to see you guys.